Good afternoon.
Good afternoon, Hugh and Christiana, and to everybody who has dialed in from good morning or good afternoon. It's a pleasure to have you all dial in. My name is Mike Curry. I am a director at Primerio, a firm that specializes in antitrust and competition law across Pan-Africa. And I personally have had the great privilege of being very involved both in a professional as well as an advocacy capacity in relation to Nigeria and competition law over the last several years. So I'm very pleased to be joined today, firstly by Hugh Hollman, a seasoned international antitrust partner at A&O Shearman, a recent merger in its own right. You brings a wealth of experience in the international context, and you're also a senior member in the business at OECD Competition Committee, a sort of think tank to advance best practice policy and legislative developments in competition law and antitrust. And I think your experience and insights are valuable from an external counsel perspective. And then joined today as well by Christiana Umanah, the head of the FCCPC's merger division. It's a pleasure to have you both join me, and thank you very much for taking the time to speak with us. And I'm sure our audience, both who are dialing in live as well as those who will review the podcast in due course, will find these sessions particularly helpful. Let's jump straight into it, which is, Christiana, the FCCPC is considered still a relatively young agency, comparatively young agency, despite having been sort of kicked off in earnest in 2018, 2019, and has very quickly become one of the key competition regulators on the continent. We have had a lot of dealing with the agency, and it's certainly a very, very sophisticated agency. It has become a very sophisticated agency in a very short space of time. But perhaps for our listeners and audience members, you could give us a little bit more context in your department, the mergers department, which is of particular interest to the international community. Give us a little bit of sense of how established the agency, or how established your department is, key members in the department, how big is your team, and give us a little bit of a flavor of the size of your department, Christiana.
Okay. Good afternoon, all. Good afternoon, Mike, once again. It's a pleasure to be here. So I will start with the enactment of the Federal Competition and Consumer Protection Act 2018, with operational in 2019. So the mandate of mergers was in another government agency called the Securities and Exchange. When the Act FCCPA was enacted, that mandate fell on us, and the Act, the FCCPA, Federal Competition and Protection Commission Act, repealed sections 118 to 121 of the Securities and Exchange Commission that had to do with mergers. And so it's now one of our core functions, and we've been on it since 2021. We had to have a joint desk with SEC to understudy them, to know what they were doing. But that ended in December 2019, and since then we've been on our own. The agency commission, yes, is quite young, but there are some giant strides. The department itself is comprised of 8 staff, including, and 7 are actively involved in the major review analysis. The commission has a total of about 311 staff and is looking forward to recruit more in the nearest future. So that's our composition. We have offices in 36 states of the Federation. We have staff in all our zonal offices. We have zonal offices, 6 zonal offices, and 2 cosmopolitan offices, and Kano, and then we have staff in all of this. But the major competition is majorly in the headquarters, and mergers and acquisitions department is in the head office.
And Christiana, in your team, do you have quite a nice blend of economists and lawyers? And where would you say most of your team members are trained? Is it locally through experience, or are they receiving training, either formal or informal training across different regions? And if so, any specific regions?
We receive our trainings both locally and internationally. We do have regular trainings. Presently, we are running one every Friday for our new staff. So we are constantly having trainings. Last year, we had some trainings. We went to Mauritius for trainings. So we are, and some of our staff had to go to Barcelona for training. So we are constantly on, and this year there are moves to efforts that are going to we're going to send our staff out. Hopefully we'll have to come to South Africa one of these days too. So we are constantly training and retraining ourselves. Yes.
I know in the formative years, not formative years, there was a lot of, I suppose, capacity building by, I think, the South Africans, but also FTC, DOJ, European Commission. Do you still have that sort of same level of interaction, or is that slowly weaned in light of the FCC becoming perhaps a little bit more established in its own right?
We had a lot of interactions with DOJ when they were here. They came, FTC, they came, we had some some days of trainings with them, and it was participatory. I'm sorry that I lost out on your last question. I didn't get you correctly. So if you don't mind, you can repeat.
I was just asking whether you still have a lot of interaction with the other agencies, some of the more established jurisdictions. Do you still work quite collaboratively with them, both either from a training perspective, but also on perhaps cross-border mergers? What is the sort of interaction between the FCCPC and other agencies?
So for now, it's a bit limited because we really do not have cross-border filings, cross-border notifications. But obviously, whenever the need arises, we can reach out to them, and they are always willing to assist us. Right now, the department is also having a training and another a university in the USA to help us build our capacity. So whenever we have those kind of issues, those kind of notifications, of course, we will reach out to them, and they are also willing to help at any time.
When you are, you're obviously responsible, and you do a lot of multi-jurisdictional filings for a lot of very, very big players, and there are so many jurisdictions with antitrust regimes to a greater or lesser extent which you need to consider. Talk us through a little bit about how you approach it. Typically, I know it varies from case to case and client to client, but typically how you would approach it. What are some of the sort of key considerations that you would find most important to understand when working out the game plan, so to speak, as to which jurisdictions do you file in, which don't you? What are the key considerations from your perspective?
Well,
okay, so when we have
go ahead.
So when we have multi-jurisdictional filing, we take into consideration the dynamics on the Nigerian market.
Christiana, can I pause you there? Sorry, Christiana. I just want to get Hugh's comments on that, and then I want to get to you about your approach to foreign transactions. But I just want to get Hugh's thoughts on some of the key facts from his perspective.
Well, I would very much like to hear Christiana's thoughts, but thank you, Mike, for this very warm welcome. It is indeed a privilege to be present here today, and I'd like to extend a sincere appreciation to both you and Primerio for organizing what I'm sure will be a very insightful webinar. Your question about what international business takes into account when they're looking at agencies around the world, as you say, I mean, when you're looking at international mergers, I think there are as many as 120 different jurisdictions around the world that have some form of merger notification regime. And clients, what they are most especially interested in when we discuss where filings are required is that they want to know to what extent these agencies will comply with international antitrust standards and practices. And in particular, one aspect that they do focus on is timing. And I'd be very interested in hearing from Christiana on timing for merger reviews and whether they have any benchmarks for how long they expect to take in reviewing cases. Christiana, I think you're on mute.
Yes. So when a notification comes in, if it is multi-jurisdictional, we have to take into consideration the different timelines of other countries. Our own country our jurisdiction is 60 business days, which can be extended to 120 if there are issues, anti-competitive issues, or reasons that we suspect could restrain competition. We could extend it to 120 business days. But nevertheless, when it is multi-jurisdictional, we have to take into consideration the time frame of the other jurisdictions so that we will not hamper their own processes in the different countries. So we will look at the impact on the market. We look at the concentration. We look at the timelines because we want it to be harmonized. We don't want to disenfranchise any transaction because of our timelines. And there's this thing that we also have in our own, we call it expedited. So we afford notifying parties the opportunity to fast track their transactions, and that gives them, it takes away 40 business days. It reduces the timeline by 40 business days. And so without even being told, we just know that once it's a multi-jurisdictional transaction, we have to make sure that it's harmonized. We just don't disenfranchise the others. So we do it timeously. We'll review it timeously. Has that answered your question?
Thank you, Christiana. That's very helpful. You say that you do take into account the timelines of other agencies and other jurisdictions. Do you reach out to them and have conversations about the matters at all, or do you just bear in mind generally that there is a global antitrust merger considerations that need to be taken into account?
So when we have a multi-jurisdictional transaction like that, and we have been informed that it has been notified in other jurisdictions, when we assess on our own market dynamics in Nigeria, if it does not have any anti-competitive effect on us, we do not reach out. But if we will also have to ask questions if it will affect others in other jurisdictions. And then if it doesn't, we can go ahead and give approval. So far, the ones we've had, when we reached out, it had no anti-competitive issues. It had no likelihood of restraining competition, and so it was approved.
I know agencies don't like overcommitting on timelines or shortened timelines, but certainly in our experience, as filings before the agency, decisions have been turned around pretty quickly, and I think that's a highly encouraging practice and standard, because it's not the same across many other agencies. And as you said, that's one of the key off-putting factors when there's just very little predictability on timing on a merger review. So I think credit must be given where it's due. And I say, Christiana, I think your department turns around mergers relatively expeditiously. I did sort of I don't know if you had a follow up on the timing question, but I did just then want to ask Christiana on foreign mergers. Sort of we have, or international mergers perhaps. Let's talk about foreign to foreign mergers. We know that foreign to foreign mergers do meet the jurisdictional thresholds that require filings. We know your filing fees very specifically have a method of calculating filing fees for foreign to foreign mergers, which is based on localized turnover, not deal value, which is the sort of benchmark for ordinary deals. How often are you as an agency receiving sort of pure foreign to foreign transactions? They come across your desk quite frequently?
We do have a reasonable number foreign that is purely foreign to foreign, but we don't really have much on them. So what we do have most times are foreign transactions that either are interested in a local entity. For example, we had one that was interested in a local entity, but it was an indirect acquisition. And so that one, the local entity it was interested in had some interest in other agencies, in other undertakings. And so we had to really look at it so that the foreign party that is coming in, the foreign acquirer, we would not have take any action that will impede competition in Nigeria. So for foreign to foreign, like you have said, we use the turnover of the local components. Some foreign to foreign do not even necessarily have foreign components. They just have some presence. And so when it is in their presence, it is just maybe the turnover. But when they do not have a presence, when they do not have a local entity in Nigeria and they just have a presence, we cannot do processing fees as based on their own turnover. So what we do is just a presence or a local entity. We look at just that particular thing that they do in Nigeria, that particular business component that they have a presence in Nigeria. Only that one. That's what we look at. We don't look at the entire deal, the entire consideration of the processing fees on that.
So is it fair to conclude that the agency hasn't yet taken any substantive decisions in relation to foreign transactions, and typically you expect foreign to foreign transactions to be processed and approved relatively expeditiously, given that it seems to be quite a finite review scope from your department's perspective?
No, that is not what it means. We have taken a decision, but this is what we do. When it is foreign to foreign, that has most times a local component in Nigeria. So it's not going to impact on competition. So there's a format we have brought out. It is called Form 2. So that Form 2 is just how do I put it? It just means that the competition analysis will not really be that robust, because there is no likelihood that it will substantially lessen competition. So based on that Form to assess them. And that is the Form 2. It's also to help the parties on their own to assess whether there's any potential substantial lessening of competition or not before they come. Nevertheless, even if they file, and when they file in Form 2, and we do our analysis, and we discover that there's a likelihood of substantially lessening competition, we will submit it to a full-fledged review. So it is not that because it's not going to impede competition, we give approvals expeditiously. No, it's not like that. So the commission has taken a decision. There's a format for it, but we just the commission just thinks that there's no need to hold on to any transaction or any approval when there's really no basis for it. So it's not that we issue out approvals so expeditiously without giving it the full depth of review and analysis.
Understood. So it's a very sort of robust screening process, I
Yes,
suppose, that you adopt.
It's still as robust as it should be.
Before we turn to some of the substantive findings on transactions, the agency has penalized parties for not notifying transactions in the past. There doesn't seem to be a practice to publish those types of decisions. Is that sort of deliberate by the agency not to publish those types of decisions, or is that in fact not the intention? They should be published, or can you shed some light on cases or instances where the agency has imposed penalties for either failing to notify or gun jumping or any other merger control violation?
Yes, when parties fail to notify, they have gone jumped, and we reach out to them. We issue notices of commencement of investigations. We invite the parties, and we actually investigate. And if they're found liable, we penalize. So I can share a few with you. One was a multi-jurisdictional, so a local was in the UK, and they had gone jumped. So they had implemented it in the UK, not gotten approval in Nigeria. So we issued notices of commencement of investigation. We invited them, and they said they didn't know. They were penalized, and they paid the fine.
Christiana,
so
you broke up an important point there. So these were parties in the UK who notified in the UK, didn't notify in Nigeria, although they had a local presence in Nigeria. Is that factual matrix correct?
The acquirer was a Nigerian entity.
Okay.
It was acquiring, and the target was a UK. And so they had implemented the transaction in the UK while they had not gotten approval in Nigeria.
Did that UK company also have a presence in Nigeria or activities in Nigeria, or was the target solely confined to the UK?
It was solely confined in the UK.
Okay.
It's a Nigerian undertaking. It's a Nigerian undertaking and doing business in Nigeria.
Sorry, I think I interrupted you there. You were about to jump in.
Thanks, Mike. Christiana, I think it would be helpful for the folks listening in to understand what are the extent of the penalties that are possible for gun jumping cases, and then what are the types of considerations that you take into account when assessing the penalty and what it should be exactly.
Okay, so the fines are like 10% of 10% of the audited financial account, the turnover. That's how hefty the fines are by the Act. But by the administrative penalties regulation, it has been reduced to 2%. So when companies, undertakings gone jump, they pay 2% of their turnover, the turnover of the last financial year. And there are certain factors that we take into consideration. We call the mitigating factors and the aggravating factors. So we take into consideration if what did they have knowledge, was it deliberate, are the directors, is it their first time? We take those things into consideration. Are they cooperating with the commission, or when they are issued notices of commencement of investigation, they disobey? Those are the certain things that we take into consideration. Are they really a large company? Are they thriving? We take those things into consideration, and that's how the fine is arrived at. Yes.
Christiana, we know that the regulations contemplate a pre-merger engagement, and that your agency encourages merging parties to engage your department even 2 weeks before a filing, or give us some context. But what is your reception to parties or legal counsel engaging your agency on a no names basis, to where there are perhaps gray areas or uncertainties about whether a filing would be required or things like that? Are you relatively open to engaging with parties on sort of a no names basis, or do you take an approach like some agencies do, which is we're not going to engage you until you give us all the information? And so what's your sense of it?
We do all. Some come on a no-name basis, and we respect their right to privacy as long as they are able to give us the correct information for us to guide them. We really do not. We do not mind. Some do not disclose their principals, but some do. Some submit documents on our portal. Of course, we have a portal for notifications. Some drop robust documents to help us guide them through. Some come in person. It can be virtual, be on phone. Some come on a no-name basis. Those who come on a no-name basis, we respect their confidentiality for reasons best known to them. But as long as they are able to give us enough information to help them navigate the structuring of the deal, that's okay by us. We do not insist that they must disclose the names. Yes.
Very helpful. Let's quickly talk about some of the substantive decisions that your department has issued, sort of where you have found, even if they're sort of locally focused cases, where the agency has imposed remedies. Can you give us an audience just a brief overview? We're probably not going to have time to go into the details of each case, but a brief overview of some of the conditions, be they behavioral, be they structural, just a flavor of what type of conditions your department has imposed on transactions of late.
Okay, so in 2019, we had this transaction that the acquirer was foreign and was had taken on a Nigerian undertaking, but the acquirer had an indirect principal who also had interest in other Nigerian entities that were engaged in the same line of business with the present target. So when the commission assessed that transaction, the commission realized that there was a likelihood of sharing of data between the undertakings that were going to be acquired. There was just one target, but the indirect acquirer had a shares in another another undertaking in Nigeria. So the commission had requested that it should divest itself of those shares in that undertaking to make sure that there was no sharing of data between the target and that other entity that the indirect acquirer had interest in. That's one. The second one is they are all local. So and there are not many players in that market. There are few players in the market, and one of them was taking on another, and so that was going to reduce. It was going to make that market concentrated, and so but then the other entity, the target, was more like a selling firm. So whether you approve the transaction or not, it would eventually fail. And so, but the commission took into consideration a lot of things, including the fact that it had a division of the bagging in a division of its business. So the commission advised them, because in Nigeria, the commission will advise that the undertakings propose a remedy. So the commission advised that they should divest of their bagging division, which is in process. As we're talking now, that very transaction, that's the stage they are about to carve out, and they had agreed to divest division of the business. And then we also had another transaction where both are local transactions. They are not, they are local entities, they are not foreign, but there was going to be a concentration because equally there are not many players in that market. And so, but they had cross board membership. So the commission advised that they should divest of on one of the board members, exchange of sensitive, and so that was a case of a hybrid. The commission advised them to relate on an arm's length basis, and at the same time, one of the board members should exit the board of the other entity. So that was a hybrid. So that's how far some of the cases that are ongoing in Nigeria. Of course, all of these are going, apart from the 2019 case that had long been dispensed with, the others are still undergoing monitoring.
Two quick questions, and then if you've got any further questions for Christiana. But the first is, does your department or your agency have formal priority sectors where it has, well, just and are they sort of publicly known priority sectors? Is it well known? And if so, could you shed some light on what those are? Question one. And question two, very briefly, the legislation in Nigeria, similar to South Africa, has a public interest section where you have similar considerations: employment, ability to compete internationally, protecting local markets. We haven't seen any decisions yet from the FCCPC where public interest considerations played any meaningful role. Just briefly, your thoughts on the relevance, role, significance of public interest considerations currently from your department's perspective, and then if you have any follow-up questions or closing remarks, I think that would be great.
Okay, so because I missed the first question because the network was fluctuating, I'll get back to that. So let me take on from the public interest ground. The last transaction I just discussed with you that the target was almost failing. Public interest was one of the considerations that the commission took because the jobs for the target firm if the transaction was prohibited, it would have resulted in job cuts, job losses for that. So the commission had to take public interest into consideration so that those employees will not lose their job. And even in the process, in reviewing, it was one of the conditions that the commission had given, that there should be no law of justice. So even in divesting that part of their entity, they had taken into consideration that there should be no job cuts. And then presently, though we have not, I didn't want to talk about this very transaction because we have not come to a conclusion. We are still reviewing the transaction. There's another transaction right now that the commission is also insisting that there should be no job cuts, there should be no losses. So the commission takes public interest into consideration. And above that, Section 100 of our Act stated the Minister of Trade and Industry that it can be represent on any public interest grounds. So it can monitor the transaction, he can observe it, he can make representations on public interest grounds. So we have that in our Act, which empowers the minister to come in. So the common interest very seriously and is going on with it. So we take public interest into consideration in every transaction that we do. Then the first question, Mr. Michael,
it was about priority sectors. Do you have priority sectors from your department's perspective? And are they public, and what are they?
We do not have priority sectors specifically cut out. We take in all the sectors, but there are some sectors that have no, they are not likely to restrain competition, but there are other sectors that whenever they come, we have to make a robust look at it. For example, oil and gas, for example, intellectual property, energy sector. So, but we don't have any like high priority. We give attention to every sector as it comes and the notification comes. Hello? I think somebody was trying to ask a question.
No, that answered my question. You, I don't know if you have any follow-ups.
I don't have any follow-ups. Christiana, this has been very, very helpful, hearing your valuable insights on the way in which your agency operates and some of your considerations and thinking through cases and how it operates just generally has been very, very helpful. So thank you so much. And thank you, Mike, for facilitating the session today. I'm sure the folks on the call have really appreciated the exchange of ideas. Thank you.
Thank you very much.
Thank you so much.
And Christiana,
thank you so much, Mike.
Just before we log off, I forgot to ask: are there any developments on the horizon? Any legislative or policy or guidelines, anything like that, that your department plans on publishing, issuing in the near future?
Yes. And thank you for saying that. I forgot. I had also wanted to say it. So as services, we realized that when the Act was enacted, an issue like digital platforms were really not taken into consideration. And so in the course of the work, we have realized that there are some recent transactions on digital markets, digital acquisitions, and all of that. So the department is looking at enacting a regulation on digital transactions and the likes, that we are looking at that. And we are we're also generally looking at the e-market platforms also, because more of them are rising. So, and any other, as the case may arise, we will constantly be doing some regulations, some guidelines, some rules on them.
Excellent and very noteworthy indeed. So thank you for adding that. Christiana, thank you very much for your time and for sharing those insights with us. To those on the call, you and I will be speaking with your colleague Florence next week on enforcement and restrictive practices. So please stay tuned for that. But I think it's vital that we have these dialogues. I think it's certainly useful from our perspective, the audience's perspective, and we really appreciate your willingness to engage so openly and frankly with us.
Thank you. And I want to add, please, when any time that you need any information from the FCCPC, please don't hesitate to reach out. We'll always be willing to assist. Thank you so much for bringing me on this, and I want to believe it's been helpful and useful. Thank you. And do have a good day.
It has been.
Hello?
Thank you very much, everyone. Thank you.
Yeah.
Thank you all.
Thank you. Yeah. Bye.
Bye-bye.